Thank you very much, Dr. Maranga. Leadership of the Chief Justice, Martha Koome, Chief Justice of Rwanda, Dr. Faustin Teziliayo, our DPP, Nudin Haji, Neil Walsh of UNODC, Ambassador Gega of the European Union, those of our colleagues, both in Rwanda and Kenya, who are joining us online, ladies and gentlemen. On behalf of my committee, I would like to thank the organizers of the conference for calling us to this very, very important engagement. A country's justice system is a key indicator of its level of democracy, rule of law, and respect for human rights. The achievement of these principles must, as a matter of necessity, rely heavily on the involvement of all stakeholders. Indeed, in my view, this gathering is unprecedented. It is a first, to my knowledge, Chief Justice, that brings together a cross-section of criminal justice sector actors to collectively reflect on the need for integrated approach for an automated criminal justice management system. I do not recall myself, in my 19 years as a judge, of such a meeting ever to discuss automation, especially in the criminal sector. And therefore, this is indeed a wonderful moment for all of us in the criminal justice sector. We know that the function of all courts is to determine cases fairly, promptly, effectively, and efficiently. And the way the courts deliver justice for the parties that appear before them is greatly influenced by the processes and procedures that guide the actions of other agencies that play a key role in filing and prosecuting cases, causing attendance of litigants and witnesses, and presenting reports and submissions before the courts. All actors are well represented here. And Dr. Maranga, thank you for reminding us of our roles as players in this sector. We know what the DPP does. We know what the Children's Department does. We know what the other players do. But what is important is that all of us must appreciate the extent to which our roles contribute to the order, predictability, and justice in the society. And therefore, a call must be made to each one of us to reflect on how to build a criminal case management system that ensures not only equal access to justice for everyone, but a system which is effective, efficient, predictable, and accessible. All of us know, for example, that we in the judiciary since 2010 have taken steps in terms of our reforms to enhance access to justice and promoting the rule of law. We have attempted to adopt new technology to automate court processes, which has resulted, no doubt, as has been said by those before me, in the delivery of improved quality, efficient, and effective judicial service. We know that this has not been the case over the years. I recall, for example, that when we attempted digital technology in 2005, we hit a wall in very many respects, and the World Bank at that time attempted to assist us in digitizing our courts by unveiling the digital auto-recording system. I was in Embu at the time, and I recall that my court had gadgets which were installed. When I left Embu soon thereafter, I left the gadgets there. When I went there many years later, the gadgets were still there, and nobody had touched anything about the gadgets, I guess, until today. In 2005, we then did the strategic plan for the judiciary 2005-2008. And we identified two issues as important in terms of management of our cases. The first was the court records management system, the CRMS, and then of course the digital audio recording, DAR, as very key in improving service delivery. The plan of 2009 also appreciated the need to institutionally appropriate ICT facilities to increase efficiency in judicial operations. We were mandated as a judiciary to develop and deploy an electronic case management system, digitize court records, and adopt audiovisual recording and transcription of court proceedings. We are still at the stages of harnessing those technologies to improve our work. When Chief Justice Mutunga came to office and then installed the Judicial Transformation Framework, he said that one of the pillars of the transformation framework would be ICT. And therefore, in 2014, he established the Integrated Court Management System Committee, which is now the committee that I chair. That committee developed the ICT Master Plan 2017-2022, and we have just expanded it to include areas of modernization of register management through automation and innovation. But all these plans, all these ideas were suddenly jolted by COVID. And Chief Justice Koome and I keep speaking about this. We said that we were reluctantly dragged into the world of technology by COVID. And so when we, on the 13th of March 2020, we scaled down our operations, it occurred to us that although we had put together a framework which would have assisted us to address the situation we were in, we were not ready. And like those children we throw to the deep end of the swimming pool, we were thrown to the deep end. We had to learn how to swim, and I believe that we swam. Why do I say so? Since 2020, we have done the following. Our e-filing and case tracking system, developed with the support of IDLO, GIZ, and GPIP, is a module of the ICMS. The solution provides for filing of cases and management of a case until conclusion. The system manages both criminal and civil cases, but requires continuous improvement to fully automate the court processes, especially in court procedures. And that's why I think this conversation must continue. The court interface also allows judicial officers to have access to court documents and make rulings electronically through the portal or email. The use of video and audio conferencing through virtual platforms such as Teams, Zoom, and Skype has also been integrated in the system, and I think this is one of the biggest achievements since COVID. Chief Justice Koome came into office and hit the road running, and with our social transformation through Access to Justice program, we are now enhancing the system to ensure that the automation process will be end-to-end to improve case-to-case management from registration to conclusion, and I'm sure the Chief Justice will speak in detail about that program. We as a judiciary and a member of the NCJ are therefore calling on other organizations and institutions in the justice system to embrace digital case management initiated by us. DPP, we thank you because in July 2020 we know that you developed and integrated your case management and document tracking system into our electronic filing system to enhance efficiency in the criminal justice system. The integration of the two systems facilitates easy access and retrieval information between the prosecution and the courts, permitting ease of access of information regarding the process and status of criminal cases. Administration of justice for criminal cases has therefore been significantly enhanced. Having so said, to improve the efficiency and availability for the virtual courts, agencies across the justice sector must be adequately resourced. The uptake of virtual court sessions has been slowed down by inadequate digital technology infrastructure such as computers and internet connections, and of course unreliable power in many courts and across the various agencies. We therefore, as agencies within the NCJ, require collaboration to ensure that technologies deployed can be harmonized to facilitate proceedings and electronic filing. This includes a combination of desktops, laptop court recording, video conferencing solutions, and scanners. Of importance also, and I think an issue that must arise in this conference, is the urgent need to revise existing legislation to ensure that they are adaptable to the use of technology in the whole case life cycle. Unless we adapt our laws to embrace technology, we shall continue struggling with what we are doing. On training, it's a challenge that we are trying to address through ICMS, but it must remain a catalyst for access to justice instead of a hindrance. And therefore, there is a need for us as court users, as NCJ, to discuss strategies of ensuring that different court users are trained and empowered to navigate through the technologies involved. As I conclude, I hope that this conference will do the following in my view. Number one, it should provide a platform for sharing experiences and best practices. And I'm particularly excited that our brothers and sisters from Rwanda are with us. We have a lot to learn from them. I know myself from experience, I've visited their courts, that they have a lot to give us. But I'm sure we ourselves have something to give Rwanda. And later, as we do the wrap-up in the evening, I'm certain that we shall have learned from each other and give ourselves lessons for the future. Number two, I believe we must demonstrate the need to review our justice system on an ongoing basis and explore ways and means of enhancing access to justice, because that is our responsibility under the Constitution. I also hope that we should develop the principles of a criminal case flow management system that is just, fair, inexpensive, expeditious, accessible, understandable, and responsive to the needs of the society. Because unless we do that, our work will be in vain. I also believe that we should generate new ideas and further initiatives to promote accessibility, efficiency, and effectiveness of our courts and all the sector players in the criminal justice sector. The success of this conference will be measured in years to come by what we resolve at the end of the day. Thank you for your commitment to access to justice, and I wish you all very, very fruitful discussions indeed. Thank you.
Thank you very much, Justice Lenaola. We really appreciate the work you are doing in the Judiciary ICMS Committee. As NCJ, we appreciate the strides made by Judiciary in terms of case management, case tracking system, and you have rightly put that Judiciary is committed to move automation to the next level. For avoidance of doubt and those who do not know, Justice Lenaola was very instrumental